I'm delighted to be joined today by Dr. Charlotte Lacroix, who is a vet and a lawyer, and she's the owner of Veterinary Business Advisors, which is a national consulting firm that helps clients on issues involving veterinary business and legal issues. Dr. Lacroix, thank you so much for taking the time to talk with me.
Thank you, Adam, and I appreciate the opportunity to be on your podcast today.
So one of the things that you have talked about a lot is the issues surrounding the legalities of telemedicine. So can you talk a little bit about how the landscape has changed lately and what's more permissible now and in what states and what is still a gray area?
So, when we talk about telemedicine, the issue that we're focusing on is the establishment of the veterinarian client patient relationship. And is a physical exam required in order to establish that veterinary client patient relationship? Now, once the veterinary client patient relationship, or the VCPR, has been established, you can practice telemedicine on your patients on a recheck basis, because presumably it's presumed that you have familiarity with the patient. But of course, if you saw a patient in February and you vaccinated them and they were pretty healthy, and then in April the client calls you and says they're lame, you're not necessarily going to say, okay, they're lame, just go ahead and give them bute, or give them stall rest, because they could have a foot abscess. And so in that case, even though you could practice telemedicine, I think most reasonable veterinarians would probably go ahead and visit and see that horse on site. If the VCPR is not established, new client, for example, or you haven't seen that client for at least over a year, you're really not familiar or currently familiar on the status of that patient, and somebody calls you, whether or not you can establish that VCPR through telemedicine is at your judgment as a veterinarian, as long as the state in which you are doing this permits it. So there are many states now in the United States, Florida, California, Arizona, that now allow establishing a VCPR, which means that when you look at the number of practices, there's more practices in the United States that can actually establish virtual VCPRs than there are not. The establishment of VCPR virtually, I think this is an evolution issue. We probably couldn't have even had this discussion 10 years ago because we didn't have the technology. Now people can send you pictures, they can send you synchronous, or asynchronous videos. You can ask as many questions as you would like. Sometimes it's even better to see horses in their natural environment in the paddock before you show up, where they know when you're driving down that driveway. And so you can actually see the patient in its real form, certainly, if you will, and you can decide at that time whether or not you should prescribe a medicine. Now you have to be careful. States will regulate this. Can you prescribe just a couple of days? Does it apply to controlled drugs? These kind of things. So you really need to pay attention to what your state does. Number one, does it allow the establishment of a virtual VCPR? If so, what are the guardrails that it imposes on you? But I think the bottom line for me is that this is happening. It happens in human healthcare. Your clients do not understand why they can do it for humans, but they can't necessarily do it for their patients. And it's happening whether we like it or not, because it's driven by the consumer, and they're driving this through the legislation. I think we as a profession need to adapt, like we've done very well in the past, and figure out how are we going to implement telemedicine on rechecks, telemedicine on horses with which we do have a VCPR, and telemedicine on which we don't have VCPR, which means we have to establish that VCPR and figure out what cases are you comfortable, which cases you're not. There's no obligation that you provide services through telemedicine. You absolutely get to decide. That's what being a professional is. You have to make some tough decisions and decide whether or not you need to see the patient. Even when you see the patient, do you take an x-ray? Do you take blood work? You're always making assessments as to what diagnostics in order to get the right answer, right? Because that's what people are paying you for. They want the right answer so that they can move on, with the health of their horse.
Yeah, that makes a lot of sense. But let's talk for a second about training. And by training, I mean not the animals, but the training of the clients. So how do you educate a client about what is amenable to telemedicine in this setting, and what really isn't appropriate, or maybe they've been reluctant to consider it at all. I imagine there is a little bit of negotiation that goes on there.
So I don't think it's a client issue. I think it's a veterinary issue. The veterinarian needs to be educated and decide in their when they feel comfortable practicing telemedicine or not. This is a veterinarian decision. This is not a horse owner decision. If a horse owner has a problem with the horse, they should call their veterinarian, and the veterinarian can work with them to decide what it is. Is it absolutely nothing? Is it something we should monitor? Is it something we should see right away? Is it something that, I need more information? Give me a video, give me some pictures. I want to see, like, when you push on the lesion or the bump, is it hard? Is it soft? And then I make that assessment to say, you know what? Why don't we try this? But I can't come out today, but I'm going to come out tomorrow. But let's try this in the interim. Or, you know what? We need to see them right away. I don't have time today. Can you ship them to our hospital or to my practice? Or we'll make it out there. I don't care if I'm there at 10 o'clock at night. This horse needs to be seen, or it can wait 3 days. That's the veterinarian's purview.
Let's talk for a second about proper documentation. I mean, that's always an issue, regardless of whether you're in the paddock or over the phone. But are there any special documentation tips that listeners can should take away from this conversation?
The exact same medical record keeping practices and principles that we follow without telemedicine. So what evidence are you gathering, and how are you capturing that evidence, right? So without any technology, you write medical records, right? But if you use x-rays, if you use chemistry, you put those results in the medical record. If you use photography, if you use video, and the technology of capturing this and monetizing it is also getting better, much, much better. And this is the implementation. And veterinarians need to talk to a lot of providers of telemedicine so that they feel comfortable that that telemedicine software, if you will, can integrate with the software in their practice management system, for example, that they feel comfortable monetizing. They're going to have to also train their paraprofessional staff as to, how do we manage this new delivery system in our practices. It's going to be probably tougher than adopting electronic medical record keeping in veterinary practices. That was not an easy exercise. But I think that this is, the path is there. It's being cleared, but it's happening. And I think veterinarians need to embrace this and figure out how they're going to deliver this type of care, because that's what they're going to need to do in order to stay competitive.
That's a good segue into my last question, which has to do with the sort of legislative landscape and where you think state legislatures that are responsible for these sorts of decisions are falling short. What do you think needs to be done to make life easier for equine veterinarians?
So, there's a lot of political arms here as to, why is this being pushed by the legislature? Is it not just companies that basically want to interface with clients, sell them drugs, and then when it doesn't work, not their problem, right? And I think this is our greatest fear as a profession. And it is happening whether we like it or not. There's these huge, huge companies. We're seeing it particularly in small animals. It is happening. And I think I'm disappointed because I don't think we're at the forefront of this. I don't think we're the ones that say, look, okay, we're okay with doing this as a profession, but these are the guardrails that have to be placed in place. We're not the ones going to the legislature saying, you want to do this in your state? That's fine. But these are the guardrails in order to protect patient and, patient health and client and the clients in general, that they're getting standard of care medicine. But that's not really happening, because I think that, the AVMA in particular is against this, and a lot of associations are against it. So while we're all infighting, and this is happening right in front of us, we are not actually focusing on how do we implement this in a proper way, because we're too busy saying, no, 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 we can't do this, it's going to harm the patient, et cetera, rather than actually being at the forefront and saying, okay, we understand this is happening, but this is how it's happening, because the legislation is being adopted, but in my professional opinion, not with the guardrails that need to be instituted, such as if a veterinarian is giving advice over telemedicine, they need to be licensed in the state in which they are giving advice. They need to have an association with a veterinarian that has a hospital in that area. So when their drug doesn't work, they can refer that client to a veterinary, to a veterinary practice. So there's things that should be there, but though we don't see those in the legislation.
Great. Thank you very much. Let's switch gears now and talk about a topic everybody loves to hate, which is non-compete clauses in contracts. So I believe it was last year the FTC did away or passed or I believe it was last year the FTC issued a ruling that said non-compete clauses were not okay, and that has met some pushback. What's happened since then? And in your experience, are you seeing fewer non-compete contracts, or has the landscape not changed at all for equine veterinarians in particular?
So just a little bit of background. The reason why the FTC had this mandate was because very large companies like the Amazons, the estheticians, the coffee companies were having people sign non-competes. And what does a non-compete do? When you're looking at it from the employee's perspective, what it does is, one, it reduces their wages, right? Because if they go to the employer and say, pay me more money, the employer says no. And the employee doesn't have the freedom to just walk and work at the next store next down the street. They can only go, and they have to go further, which means they have to move their family. They have to get out of the community. That is such a burden that they're like, okay, well then I guess I won't get my raise. The other thing is it also pressures or prohibits them or doesn't to not be able to leave the place of employment. So if the employer doesn't, if they don't really like where they're working, but they really have no other choice because their children are at school, et cetera, it keeps them at that place of employment. That's what the federal government was trying to get at, was trying to give the labor force more freedom and more abilities to leave jobs and greater abilities to increase their wages. So that was the background. And anybody from Texas, you got to love Texas, because Texas is like the first state to sue the federal government. And so when this came out, the FTC, the first day it came out, Texas was all over it. And so it went back from stalling this and this and this. But at the end of the day, months and months later, the ruling did not go anywhere. It was stalled. And then when we had a new administration, this is not going to go anywhere, certainly anytime soon. And even some of us in the legal community were kind of scratching our heads wondering, how does the federal government really have jurisdiction over businesses that are just within the state? They're not crossing state lines. They're not receiving funding. So we don't really understand how they get that jurisdiction, but it never came to that, certainly anyway. But behind the scenes, and you point to this, Adam, behind the scenes, what we've seen is the states, as a general rule, we're seeing a movement of disfavoring now non-competes. Now, keep in mind that lawyers don't have non-competes amongst themselves. So judges probably are a little bit puzzled as to why they're there to begin with, but I'm being facetious. But what we're seeing is some states void them altogether. So there's like California, North Dakota, Washington, D.C. You can't have them. Minnesota introduced a law in 2023. So what we're seeing, and California has made non-competes illegal for a very, very long time, but basically we're seeing more. Or what they're doing is non-competes can only apply to high wage earners, so like over 100,000 or 120,000. So it doesn't apply to people that are making $40,000, $60,000. Or they have Massachusetts would be an example where they have garden leave clauses. So if you want to prevent somebody from working for a year after they cease from working, then you have to pay them that salary for a year, which you can see is quite the disincentive. Here's the reality: is most, I think it's a little bit different in equine practice. But because we go to the farms, and rather than the clients coming, certainly coming to you. But if the goodwill with the client is established with the practice, not with any one veterinarian, that client is likely to just stay with that practice, especially if you interchange the veterinarians that see that client. Now, I know that there's equine client. I mean, I'm a formerly equine veterinarian. I know what it's like, that will like not see anybody. But I came from a larger practice and they will see other people. Sometimes when it's a particular lameness or issue, they only want to see that person. Well, that's fine. But otherwise, they do establish a relationship with all the veterinarians. So I think the message to your audience is pay attention to what's going in your state. From the employer's perspective, you should still have them in your contract because you bring an associate in, you basically introduce them to your clients, you introduce them to your operations, and in the states that they're legal, you absolutely should continue putting them in in your contracts. They may only be 1 year, and the geographic area should be what your zip code analysis of where 85 to 90% of your revenue comes from. And don't use a multiple of 5 because it looks like you made it up. If you have a three mile, a 33 mile versus a 30 mile, there's just that perception that like, where'd you come up? If somebody says 33 miles, they're like, it's not like 30 or 35 where you just made it up. But you will have to establish to a judge to say, look, 85 to 95 to 90% of my revenue comes from this. I'm not asking for more than what's in my trade area. And I think that's the exercise. It's not a hard exercise, but it's a big exercise that employers don't do, which jeopardizes the enforceability of the non-compete. And keep in mind, in order to enforce a non-compete, you got to get to a judge. Getting to a judge is a very, very expensive proposition. It can cost tens of thousands of dollars. And the employer typically has more money to put towards an attorney than an associate. And so many associates will not challenge well-written, supportable non-competes because they just can't sustain the financial battle.
So this question might sound quite naive, but are there circumstances other than desperation in which you would advise an associate to sign a non-compete agreement? In other words, and maybe are there reasonable non-compete agreements that?
Well, yeah, and I represent both employers and employees, and I see both sides. And from the employer's perspective, I say, look, if your non-compete is enforceable in your state, have them because you should be protecting the business that you've invested tons and tons of time and money in, but it's got to be reasonable. You can't be asking for more than what's there. And from the associate's perspective, I explain, look, having a non-compete in this state is not an unreasonable ask because they're trying to protect the business and they don't want to bring you into their household basically only for you to like be pissed off at them and then just say, well, I'm leaving, right? And then you just set up next door. So, but again, when I counsel associates, I say, make sure, it should be based on where the revenue and that employer should demonstrate that. From an employee's perspective, generally it shouldn't be longer than a year, maybe 2 years. But here's the thing, this associate might be looking at a practice that has really good opportunities, such as training and access to some really good horses and great paraprofessional staff. And that's what's driving them working for the employer. I mean, generally, you should not make a decision based on a non-compete. That should not drive the economic decision or the employment decision unless that non-compete is so ridiculous and the employer is so calcitrant to change anything. And I also want to add that what we're seeing more of, like in the states that don't have non-competes or they're just too difficult, that you don't want to bother with them, or you want the associate and they won't sign a non-compete. I mean, all this is about negotiation leverage, right? That's what determines the outcome of most of these employment agreements. If you have well-counseled parties, but is a non-solicitation clause. So you should also have a non-solicitation of clients. You should also have a non-solicitation of employees, and there should also be a confidentiality agreement that should be properly drafted and rock solid.
Let's talk in the remaining time we have about another issue in contracts, which is retention clauses. So seems like relative to a decade ago, you're seeing a lot more of these. Why and how are they good for associates?
So I think we really started seeing them in corporate consolidator contracts. I think that's kind of a big one that started introducing them, and then they would be paying 5,000, 10,000, 15, 25, 150,000. It really depends on the value of that employee to the given set of circumstances. And these retention bonuses could be paid upfront. And if the employee didn't stay 1 year or the 2 years or whatever it was, they would have to reimburse the entire amount, which is not always fair, because if the person dies or disabled, or the employer terminates them, and many of these arrangements, the employer reserves the right to terminate the employee for no reason. And that's really potentially gaming the system, right? So you might sign on to a $50,000 signing bonus, and the employer terminates you on month 11, and you have to pay back the entire $50,000. So, that's where we've seen a lot of them. And I think what's happening is the private practices now have to compete with that and provide these signing bonuses, these retention bonuses, which can either be given at the front, or I think, so here's the thing. As a private practitioner, if you have to hire an attorney, it costs you money. Corporate consolidators have attorneys as employees. They can write as many letters as they want, to employees that are breaching a contract. So when I'm representing private employers, what I try to negotiate is try to get it so that you pay the retention bonus after the candidate has stayed the requisite period of time. So if you stay a year, I'll pay you $10,000. If you stay 2 years, I'll pay you another $20,000. Or I'll pay you $5,000, whatever it is. I mean, these signing bonuses are all over the place. It could be as little as $2,000. So you have to vet the set of circumstances in order to advise a client as to what that should be. And it talks about, what are the alternatives for the candidate. I mean, there's lots of factual things that go into deciding what the retention bonus should be. When do you go ahead and pay it? And I think the other thing that we're running into now is you see a lot of corporate consolidators, they're providing equity in their companies in exchange. So they, rather than giving them a signing bonus or retention bonus, they say, look, we'll give you $100,000 worth of equity, which is not cash, right? It's just value in stock. And you will vest over a 5-year period. The problem with those, and the reason why they're doing this is because when you give someone equity, now you have a very serious non-compete that is clearly enforceable because they're partners. They're no longer employees. And candidates have to be very, very careful signing those documents, because the non-competes will often, in the equity documents, are typically broader and apply to all the practices these companies own, rather than just the practice that you're working at, And the other thing is, you can't get rid of the equity. You can't go to the company and say, buy my equity out, even after you're vested, because they don't have to buy it from you. And you may have to wait years before there's an event. And even if there is an event, they can roll over your stock into somebody else's stock. So those are very, very tricky. But the problem with those is those non-competes are in place for as long as they own equity, which is a lot longer than an employment agreement. I mean, you could quit, but you still are bound by a non-compete indefinitely because you signed those equity documents.
So those are golden horseshoes you really want to be careful about.
Ooh, yeah. And, associates don't have any money. They don't know how to read it. Like, a lot of lawyers don't know how to read those 50-page documents. They're very, very, specialized. Just like in, you got Western, you got dressage, you got 3-day event, you got hunter jumpers. I mean, hunters, and, they're all horses, but the conditions that they get and the conditions you treat them, they're different. And you've got to be experienced in that field if you're going to deal at the very high level. And these documents are very high level and complicated and very, very tricky. So I think what we're seeing is this, and now private practices are like, well, I want to offer equity. Well, that's a lot different thing, because you don't have a platform company where you can offer, 10 shares and it be, such a very small portion. And having co-owners in a small business is a whole different aspect than companies having many, many, little shareholders.
Well, Dr. Lacroix, thank you so much for walking us through these issues. It's an interesting landscape and changing all the time. So maybe we can catch back up with you in a few months to see if anything has changed.
Happy to do so. Thank you for the opportunity.